Welcome to Baker's channel where stories unfold, covering trial dramas untold. Grab your seat, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's channel, action's hot, dramas and fun, all we've got. Discuss, debate, break it down. Baker's channel, Jeff's the best in town. Lawyers smart, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's channel, action's hot, draws and fun, all we got. Discuss, debate, break it down. Baker's channel, Jeff's the best in town. Damn, please let join the crowd. Baker's channel, we're live and loud.
Good morning, good evening, good afternoon, wherever you are, whoever you are, and no matter what you are. Good morning, Jamie.
Morning. Morning, everybody.
How are we doing today?
It's Monday.
Best day of the week.
Is it?
Because then you have an entire week to look forward to.
Okay, sure. Where is Monty?
I think out in the garden, making sure that everyone has a passport to pass by him. He's not as cuddly as Molly is.
No.
He's more, I want pets when I want them. The rest of the time, just leave me alone.
Typical
So
Monty.
he's happy that he can. I have with my patio door have a mat, and he likes laying there because there's sunshine. So that's what he's been doing most of the day. And he's a weird dog. His mouth is
Whose
too
dog
small
is it?
to grab a tennis ball.
Oh. Whose
So,
dog is it? Is this your other brother?
the other brothers.
Yeah, exactly, Jess. So he's a cat masquerading as a dog.
Kinda, yeah. I was doing my pre-stream nap, and then he came in. He just stood because he can't jump. Molly just jumps up and puts herself under the cover, but he was standing and started growling until I petted him, and then he laid down and slept. So
I love him so much already.
yeah, he's a sweet little doggo.
He's like a Baker dog. He's so a Baker dog.
Yeah. When I want it, give it to me. If not, just leave me alone.
Just leave me alone. Let me do whatever I want to do.
So, but who's not a Baker type person is Carly Madison Gregg. Because hopefully there will be a live streaming today of her pretrial hearing. It's a 14-year-old girl from Mississippi who allegedly pew-pewed her mom in the face, then called her friend and said, "Hey, something bad happened. Have you ever seen an unalive person before?" And called her friend over, who came over and saw it. When the stepdad arrived home, she popped him in the shoulder. So, and she then ran away and was apprehended half a mile away from the house. So,
She
pretty
seems like a nice girl.
Pretty scary. They have 2 security cameras in the home where she's goes walking into her mom's bedroom. Then you can hear the pew and a scream, and then pew, pew. Twice in the face and once in the chin. And they could, on the security camera, they say they could see her hiding something behind her back. They believe that was the pew. So, yeah. And
So if like we know all this information, like people know she did it and she called her friend over to do it, like is she like not guilty by like insanity or something?
well, they have had a competency hearing. I have that lined up if the other one doesn't go live. So I don't want to go too much into it, so we can watch the competency hearing if it goes. According to an email from the Court TV correspondence team, hearing has been moved from 10 a.m. Eastern to 2 p.m. Eastern. Well,
Yeah,
I love
that's a
that
bit.
you give it to me 6 minutes after my stream started. Thank you so much, Jemima. But then we can do the competency hearing, and then we might come back at 2 p.m. if it's leave. But yeah, it's kind of a crazy case. It's let's do this one. This this is a preliminary hearing from April 16th. So we can try and watch it and see what they say. Probably put on your earmuffs if you have kids around. It's yeah, this is one of the not so good ones. Thank you so much, Jessica. And again, she's 14 years old. Notice her right hand. Yes, she was found guilty in manslaughter within 3 hours.
All right, roll the record at 24-15875-1, the state of Mississippi versus Carly Madison Gregg. This is several things. It's an interest of justice hearing. It's also a preliminary hearing, and it's also a bond argument hearing. Well, we're going to do all those three things. And we'll start with the preliminary hearing. I have sworn in the investigator in this case, Security Investigator Zachary Cotton. The state is represented by the Honorable Mary, the defendant represented by the Honorable Richard Todd, Kevin Camp, and Caleb Coleman, who I believe Mr. Coleman and Ms. Todd are here representing Mr. Gregg. All right, that being said, and I will tell the audience too, as it relates to a preliminary hearing, most of our experience with courtrooms is on TV, and we understand from our TV watching that, they talk about beyond a reasonable doubt. That's the standard, the burden of proof in a criminal trial. That's not what this is today. This is a preliminary hearing. What a preliminary hearing is it reasonable, one, to believe that a crime has been committed, and two, is it reasonable to believe that the defendant committed the crime? That's it. So while beyond reasonable doubt is here, the standard for probable cause.
April 16th. As a note, when a minor is charged as an adult, federal law requires hearings, I think, every 60 days to ensure they should continue to be held at an adult facility. Gracias. Hey, Plolas. Yeah, so people understand it. Janine, Celestial. Spent 3 hours listening to Terrence Howard on JRE, and now I'm here. I don't know.
Is down here. So just make sure we all understand that as we go through this process. All right, so I mentioned that Mr. Investigator Cotton has been sworn on the stand. Mr. Berry, you can go ahead.
Thank you, Your Honor. Now, before I proceed, I know this is a preliminary / bond hearing, so the state will probably list a few more facts that are for probable cause, just so before we make a full determination.
I try to make them a little more descriptive and take out too much of the clickbaitiness and the bad words. So it takes me a while, but I think they're getting better.
Fair enough.
State your name for the record,
Zachary Cotton,
and where are you,
Rankin County Sheriff's Office.
and what's your,
Investigator.
were you working on March 19, 2024?
Yes, sir.
Did you get a call about a shooting on that day?
Yes, sir.
Could you tell the judge about what the call was about?
Our dispatcher received a call. The person on the phone was frantic. The exact details were not clear, but it was something to the effect that their child had shot at them and shot them in the neck. Deputies responded to the scene, were met with a male at the door, and found a deceased female inside of one of the bedrooms.
What if anything, did officers observe about the male?
He was upset. He had been shot in the shoulder, and he had said,
He was upset he had been shot. Jamie?
What?
How many times have you been pewed?
Never.
Do you think you would be a little bit upset if you had been pewed?
I kind of think I would.
Yeah, I kind of think I would say, dang, I didn't like
Might
that.
be a little irritated, you know?
Yeah. Say, that's Mondays for you.
Oh, I have the Mondays.
Go roast some vegetables. That his stepdaughter was the one that had the firearm, that he got the firearm away from her.
And was, at that time, did he identify the shooter?
Yes.
What's the person's name of the shooter?
Carly Gregg.
Are you familiar with Carly Gregg?
Yes, sir.
She had courtroom today.
Yes, sir.
Did you report her out to the court?
He's sitting over there.
Was Miss Gregg on the scene at that time?
No, sir, not at the residence.
Okay. What was the next thing that happened?
Deputies were attempting, and law enforcement in general were trying to observe the area to see if they could locate the suspect, Carly. She was later found approximately half a mile down the road and taken into custody.
Was the murder weapon and attempted murder weapon recovered?
Yes, sir.
What was the male's name? Just for,
Heath Smylie.
was he taken to the hospital?
Yes, sir.
Was the statement eventually taken from him?
Yes, sir.
And it matched the 60 what you just told the court?
Yes, sir.
All right, let's talk about, was there any surveillance of this?
Marissa, I love you ask me those questions. It's a four-legged dog.
Wait, where'd he go? I missed him.
He's standing on the table.
Oh, show his face again. Oh, look at him. Oh, he's such a Baker dog. That's the kind of dog you need. Look at him.
Oh, he's so heavy compared. He's not much bigger, but he just weighs 5 times what she weighs.
It's like, put me down. Aw,
He's a cutie,
he's cutie.
but he doesn't really understand that he has to be on. It's Molly is better at YouTube.
She is. She's a natural.
Marissa, this is the investigator in the case.
Video cameras in this incident.
Yes, sir.
I can tell what you observe generally from this photo.
There's a exterior camera. It's in the garage. Shows the Carly and her mother, Ashley, right home. There's another camera that's located in the kitchen. The kitchen camera shows that after they walk into the residence, that at some point Ashley goes into Carly's bedroom. Carly goes outside with the dogs. Eventually, Carly comes back in after Ashley's taken some items out of Carly's room. Carly walks back in, notices her mother is in the bedroom, and then proceeds to walk in the direction where Ashley and Heath's bedroom is. You see her come back into view of the camera. She has her hands concealed behind her back, view of the camera. She looks into the kitchen and then proceeds to walk into her bedroom, and then you hear a gunshot, a scream, followed by 2 more gunshots.
Lady Di 2. Stay away from France and tunnels. This trial is about a 14-year-old girl who allegedly put 1 in the chin and 2 in the face of her mom and 1 in the shoulder of her stepdad. This is a preliminary hearing to see what evidence they have and if they should keep her in prison. I have another one lined up for later where they are talking about her competence. Jamie?
Competency.
Exactly. Because she might be a little wackadoodle. Something about changing meds and stuff like that, but haven't looked into it too much.
Carly proceeds to return to the kitchen, concealing her hands behind her back. You hear a heavy object being set down on the counter, and then she proceeds to get Ashley's phone and begins texting on it.
Do you know who she was texting?
I believe it was Heath, based off the text messages that he received.
From the text message, did it appear that she was impersonating her dead mother?
Yes,
What was the substance of those texts?
essentially asking about how long it would be till he got home.
On video, is anybody
Oh, so she texted her stepdad and asked how long till you get home?
Oh boy,
That's nasty.
that's scary.
That's pre-planned.
Mm-hmm.
Hey, Betsy.
else besides Mr. Heath and the defendant present? Anybody else there?
But it was just Carly and Ashley there during that time.
Ashley?
Yes, the deceased.
Okay. Did the video show the defendant running away?
Yes, it shows when Heath comes up, the interior camera had been taken down by the time Heath comes home.
Who showed that? Who took that down?
Carly. Then Heath comes in, you hear some gunshots, and then you see Carly run off.
Did anybody else run off with her?
Yes,
Who's that?
one of her friends.
All right. How did the friend get up there?
She was driven over there by her father.
Why was she driven?
Carly asked her to come over.
Do we know for what purpose?
She showed her deceased mother to the friend.
She showed her deceased mother.
Yes.
Do you know why she asked her over there?
Not entirely sure. She just said it's an emergency. I need you to come over.
What is the time difference between the killing of his mother and shooting the shot?
Approximately 45 to 50 minutes.
Were you able to recover? We talked about these cameras. Where were the cameras found?
There was the one that was in the garage that was attached to the garage door opener, the device itself for like the light is found and all that. And the other one was later found in the fridge of the residence.
And what is the deceased full name?
Ashley Smylie.
And did you talk to someone named Brooke in association with this?
Yes.
Tell the court about the conversation with Brooke.
She essentially said that she was invited over to the residence by Carly, was unsure of what for. She had walked in. Carly asked her if she had ever seen a dead body before. She said no. Proceeded to show her deceased mother that was in the bedroom. Showed the gun that she used to shoot her mom. Told Brooke that she had 3 shots for her mom, and then she's got 3 more for her stepdad, 2 to the head, 1 to the chest.
All right, in between those 45 minutes, and this is, I think, for purposes of time here, what was Carly doing on camera? Anything you might seem like?
Aside from going back and getting the phone and begin texting, she appears to be singing to her dogs. Not really quite sure about the audio is not really clear about what she's doing, and then not long after that, the camera.
Did it appear she was aware of those cameras?
Sorry, it happened in March. Did they say 23rd or 24th of March? So this is a couple of weeks later they have this hearing.
What year
It
did this happen?
was, I have an article up here. No, it doesn't have the date, but it was in March someday. In March this year.
Oh, wow.
We are in the wonderful state of Michigan.
You said Mississippi.
Yes, Mississippi. Yes, she is in big people jail because this is first degree.
Big people jail.
Can someone give Scott an update how to mod? I don't know.
Yes, sir, because she had her hands
Just
concealed
yell
behind
at
her back
them.
the
They
entire
don't do
time,
anything.
in which she's believed to have the firearm.
Court's indulgence. No further questions, Senator.
All right, Mr. Otter, Mr. Cole, number 20.
Good morning.
About what time did Ashley and her daughter arrive home?
It was approximately 10 to 15 minutes before the shooting occurred.
And do you know what time the shooting occurred?
It was at approximately 4:14 in the afternoon that day.
And what time did Brooke get to the Smylie residence?
Approximately 4:50.
4:50. And how did you corroborate the timing that Brooke arrived at the residence?
Based off of the text messages between her and Carly, and she had texted her saying that I arrived here, met your house, I'm outside.
This is a replay because there was supposed to have been a hearing now at 10 p.m. Eastern, but apparently it had been moved back to 2 p.m. Eastern. So just to wet our feet, get into what the trial is about, we are watching earlier hearings.
Mm-hmm.
No, Jamie said it wrong. It's Mississippi.
And when you arrived at the crime scene, were there any other video cameras at the house?
Not to our knowledge, just the one that was in the garage, and then there was a doorbell one that had been ripped off the wall.
And where was the doorbell camera?
It was inside the residence, to my knowledge.
And did you take that into evidence?
No, because it didn't have an external SD card. After speaking with Mr. Smylie, he said that there was no footage that could be pulled off of it.
Did you fingerprint it?
No, sir. No, ma'am, sorry.
And when did you first speak to Brooke?
Later that evening.
What do you think that?
The date that it occurred, the 19th. Yes, ma'am.
When did you first learn that there was a second person in the home?
When we met with her at the sheriff's office.
Yeah, Your Honor, I'm going to object to this line of question. I realize we got into this on direct for purposes of bond, but that's just for purposes of bond. I'm not sure how much this goes to, unless this is for argument as a bond. I'm not sure it goes to probable cause.
I'm gonna let you go a little bit beside that. I don't need a whole lot of this.
I'm sorry, and you can answer.
Sorry, can you repeat the question?
Yes, and when did you first meet Brooke?
It was approximately 8 or 9 o'clock that night. I'm not sure the exact hour.
Of the March 19th?
Yes, ma'am.
And how did you learn that there was a second person at the home?
She had come to the
Melanie, you've been along on this channel enough to know that I don't know anything, but I'll blame Jamie whenever I do something wrong. So Jamie
He
said Michigan.
Michigan, but
Jamie said
it was-
Michigan, and I said no, Jamie. It's near the mighty Mississippi River. Jamie does that all the time. She doesn't hear what I'm saying. Yeah.
sheriff's office with her father.
And were you aware of this?
Couch juror, I put it in the scroll on the bottom, but allegedly 3 holes in her mom's face and 1 in the shoulder of her stepdad. First degree.
What of these statements did Mr. Smylie make to you about Carly's state of mind on the shooting?
I did not speak with him directly. I know an investigator went with him to the hospital, but he was extremely distraught and it was hard to get anything out of him due to the circumstances. The only thing that we really have is what he told the initial deputies about how he had been shot, and then his stepdaughter was the one that had done it.
Have you met with Mr. Smylie since he was released from the hospital?
Yes, ma'am.
And did you have any conversations with him at that time?
Yes, ma'am.
Okay. And at that time, what did he tell you regarding his stepdaughter's state of mind at the time of the shooting?
When he said when he walked in, he was met with a gunshot, and that he wrestled over the firearm, and that Carly had fallen backwards, and that her eyes were really big, and he said it looked like she had seen a demon or something to that effect, and she was screaming and ran off.
Did Mr. Smylie also make statements?
The ones in the fashionable yellow and striped clothes over here are other people waiting for their hearing. They are seated in the jury box right now. If you watch the Sarah Boone, it's the same setup. When she was in the first couple of hearings, she was sat in that big empty corral. That's the jury box, but they use it when they have arraignments. So they just sit there and wait for their case to come up. So everyone is brought in, have to sit there, and then they say, Mr. Smith, or you are charged with DUI. And then probably you'll go to court on Smabbity, the smackety fmudden of Yevyemba.
Regarding Carly didn't seem to recognize him?
It's something that he said he believed that at the time that he thought that maybe she had thought that there was someone trying to break into the house, something to that effect.
And did he also make a statement that Carly did not seem at the right time?
Something to that effect, that she had seen a demon.
Also, isn't there a recording of the incident between, where you can hear from the video camera in the garage, Carly and Heath's confrontation in the house?
Yes, ma'am, some of it, yes.
And how would you describe Carly in that video recording?
You can just hear screams, you can't see anything. So I was not sure who the screams were, if they were Heath or Carly, but there was screams. He asked Carly what's going on, something to that effect, and then that's the end of the audio. So you see her run off.
Does he also make a statement in that audio recording where he announces, Carly, it's me?
I believe so, yes.
So that seems to imply to you that you did not believe.
Your Honor,
her
object, I'm going to call for speculation as well. Object this is speculation.
Yes, statement. And to your knowledge, what medication was Carly taking at the time that this
Your Honor, object as to relevance.
practice to our argument?
Bonjour, ça va?
Okay.
At the initial date that this occurred, there was no knowledge of her taking medication. At the time that she was arrested, it was later found out that she had been on some prescription medication.
And do you know what prescription medication that was?
Not all of it, I believe she had been taking Lexapro.
And do you know how long she'd been taking that for?
It was, to my understanding, she had changed it at the end of the week beforehand, but not sure the exact date.
The end of the week before the incident?
Yes, in the prior week, yes, ma'am.
So somewhere around Thursday, Friday before?
Yes, ma'am.
Yeah, because it sounds really bad if it could be pharmaceutical reasons she did it.
Yeah.
So of course they don't want to talk about that. Yeah, Lexipro, I think, was the name they gave.
Yeah, Lexapro.
The incident happened that Tuesday?
Yes,
Is that accurate?
yes, ma'am.
And is it also true that when Carly was found half a mile down the road from the scene of the crime, she actually turned herself over to law enforcement?
Well, they saw her and stopped and asked if she was the girl that was involved in the incident up the road, and she said yes.
Had she flagged law enforcement down?
Not to my knowledge, I believe they just spotted her.
And how long were the investigators, how long was the crime scene inspected and secured before you turned it
Can I
over?
interject as to relevance? I'm not sure what this has to do with probable cause or bond.
What is the role, Mr. Stockton?
Your Honor, it just goes to all of you the bond that Carly Collins been disarmed.
You heard Thomas what?
Her home is no longer a crime scene under investigation.
Mr. Perry?
I think we could just ask, is there about the crime scene? I don't think it has to get into the time of that.
I'm gonna sustain the objection. Ask your next question.
Are you still investigating the crime scene or has that been turned back over?
At the residence,
Yes.
it's been turned back over.
And what else did Brooke tell you in her statement?
As far as what, essentially that she had gone over to the house, that she didn't know what she was going there for, that she had showed off her dead mother and then asked her to go outside, and she was about to, that Heath was about to be home.
When did Brooke leave the residence?
At the same time, I told her did.
So Brooke was there at the time of the second shooting?
She was in the backyard.
And you said that there was a recording that showed Carly singing to her dogs after she had apparently shot the mother.
Yes, ma'am.
Who else have you talked to in regards to this investigation?
All right, again, I object as to relevance as probable cause.
Sustain.
And what, if anything else, was Carly seen doing in the video footage between the 45 to 50 minutes it took between the first shooting and for her stepfather to arrive home?
She comes into view in the kitchen, gets the phone, starts texting what we believe is Mr. Smylie, then walks back into her room, and then she walks back in and appears to let the dogs out, and the camera gets unplugged. So it was just a few minutes prior. There wasn't a whole entire duration of the interior camera.
So she unplugged the camera as well. Yeah, this is that's first degree. That's yeah, it's because there's a lot of premeditation in this case.
Mhm.
Jamie, do you know what butterfly is in German?
No.
Schmetterling.
Schmetterling?
Yeah.
Shut off a few minutes after shooting occurred.
And where was the mother's body found?
In Carly's room,
And how many gunshot wounds had she sustained?
3.
3. And where were those gunshot wounds?
She had 2 inside of the face and 1 underneath the chin.
And were you able to recover the bullets?
Yes, ma'am, 2 of them. Well, the projectiles,
And how many bullets were you able to recover from the crime scene overall?
from the crime scene, there was some fragments that were shot at Mr. Smylie that were recovered. And then there was none of the one from from Ashley that was recovered. The other to recover during autopsy.
But all three bullets, that were fired actually made contact with her.
Yes.
And how would you describe the bedroom in which Ashley was found?
Objection again as to relevance, Your Honor, it's to probable cause or to bond.
What is relevance?
Your Honor, we're just going into
Your Honor,
part of their investigation and questions as to whether or not what's being described is in line with information from other witnesses.
Well, this is not a discovery opportunity. This is a preliminary hearing and a mock hearing. So I'm going to sustain the objection.
And do you suspect anyone else at this time had any involvement in the shooting?
No, ma'am.
No further questions, Your Honor.
Ms. Berry, you reread.
just one follow-up based on her cross-examination. What, if anything, did the defendant tell, I believe it was Jordan at the jail?
When she was provided with her paperwork to show her bond, she made a statement to the effect of, oh, you can kill somebody and pay a lot of money and get out of jail.
No further questions, Your Honor.
You should.
The Danish word for butterfly is sommerfugl, which translates to summer bird. And
Summerful.
Summerbird is chocolate company. Tom Gillis, thank you so much. And good morning to you as well.
Hi, Tom.
If anyone, Lefty, needs some help with their golf swing, go look up Tom's YouTube channel. He's a golf pro. And Lefty is a golf amateur. Well, he's not even good enough to be called. He's a putt-putt amateur. Thank you, Tom.
Say that again.
Nothing other than argument, Your Honor.
Okay. All right, at this point, the rules of civil or criminal procedure as it relates to preliminary hearings, we'll get into the bond here shortly, but Mississippi
Yeah, you have one digit on your hand. That's your handicap. I know that.
Rule of Criminal Procedure 6.2 dictates that at the close of the prosecution's case, which has happened now, which includes the cross-examination of the prosecution's witness by the defendant, which also took place, the judge shall determine and state on the record or state in open court whether the prosecution's case established probable cause. So that's where we are according to the rules at this particular point. Ms. Gregg is charged with count 1, first-degree murder that she had feloniously caused death to Ashley Nicole Smylie. Charge 2, attempted murder that she did attempt to cause death to Heath Smylie, shooting him with a handgun. Those are the 2 charges. As I mentioned earlier, the standard burden of proof in a preliminary hearing is just what is reasonable. Based on the testimony of the investigator, I do believe it's reasonable to believe that the crime of first-degree murder has been committed. I do find it reasonable to believe that the crime of attempted murder has been committed. I also find that it's reasonable to believe that Carly Madison Gregg committed the crime of first-degree murder. I do also believe that it's reasonable to believe that Carly Madison Gregg did commit the crime of attempted murder. I am therefore going to find that probable cause exists on both charges to proceed in this matter. I'll bind Ms. Gregg over to wait the actions of the grand jury. That being said, the rules of criminal procedure at this point dictate that the defendant may then make a specific offer of proof, including the names of witnesses who would testify, or the defendant may produce the evidence offered. So Besides, as it relates to the probable cause hearing, do you have anything at this point?
No, Your Honor.
Okay, that'll conclude the preliminary hearing in this matter. Now we will talk about bond. So either Ms. Todd or Mr. Coleman, whichever one of y'all wants to argue your bond argument.
Monty doesn't really bark. He growls. It's Jamie's dogs. They probably saw a Schmetterling 2 kilometers away and had to tell it, don't come near.
Yeah, they do.
In Dutch, it's Vlinder. In Icelandic, it's Vidruldir. In French, it's Papillon. I knew Papillon.
Unless you are coming inside to pet them, they'll tell you to get back.
Carly's precinct bond is currently at $1 million. Carly is 14 years old, has no prior criminal history, and prior to the incident on March 19th, no prior history of violence whatsoever. To the contrary, prior to the incident on March 19th, Carly was an exceptional student with good behavior. In fact, she made a 30 on her ACT at the age of 13. She skipped the 4th grade, so while she is now a sophomore at Northwest Rankin High School, she should be, according to her age, in the 9th grade freshman. Carly also was student of the month and I believe student of the year at Northwest Rankin High School prior to this incident occurring. Carly has no income, she has no job, she has no passport, no driver's license, and no vehicle, so she's certainly not a flight risk. Moreover, all of Carly's family, most of which are here today in the courtroom, Your Honor, live either in Rankin County or the surrounding communities. Carly doesn't have family out of state, nor does she have a way to get there. Also, this has been a very public or more public crime, so Carly's face is known to most people. So if she were to run, she would be easily recognized. But if she ran, it would be on foot, so she probably wouldn't get very far before she was picked up. Moreover, Carly turned herself over to law enforcement after this incident occurred by flagging down a patrol car. She has demonstrated a history of her willingness to turn herself into the court. Since she's been detained, she's not been in any trouble or caused any concerns after the incident, other than the medication having to be adjusted multiple times by a nurse practitioner, not a psychiatrist. Carly does not have a job, an income of any sort, a bank account, or any assets. She does have family that will support her, and both her family members, including her maternal grandparents, maternal aunt and uncle, maternal cousins, and also her stepfather, support Carly's bond being reduced. Carly is currently being held, as the court noted earlier, in almost complete isolation for 23 hours a day. She has not, today was the first time she's seen the outside in nearly a month. This type of extreme isolation is very difficult on adults to bear, let alone someone with the fragile mind state that Carly has right now. She cannot be provided with the mental health care that she needs at her current detention facility, but she could if she were released on a secured bond and placed on house arrest with an ankle monitor. These alternative options that are available to the court with those secure courts, with those secure Carly in a restricted confined area, which would keep her from being flight risk and would also help protect the public and Carly. Moreover, Carly's family supports her being released on house arrest so that she can get the mental health care that she needs, and also have contact with family members. There also can be other restrictions that the court can keep in place as far as when she can or if she can leave the confines of a residence, social media contact, things of that nature. But Carly could also be allowed to continue attending school online while she waits indictment. It can be months before she's indicted, and at the current bond, with no income, no assets, no ability to raise those funds, nothing to sell, get those funds, not even a check to write. Because again,
More on that later.
she has no bank account. Carly is basically being fired from home, and it's nothing short of punitive. She has no means of raising these funds.
The guy who's playing Sarah Boone packing his suitcase right now should really stop doing that so we can hear what she's saying.
That's why we would ask them to consider reducing Charlie's bond to something that she could afford, and we would ask for an unsecured bond. Moreover, the detention center that is meant for adults is not equipped to do things like provide Carly with schoolwork, with mental health care, with exercise. Well, currently, she doesn't even have the ability to meet with visitors, as the court's well aware of. Based on Carly's tragic mistake, she's already taking a full term, and we've not even got to the indictment. If it continues at this rate, Carly's fitness to stand trial will be at risk by the time we get to the trial. And again, both the living victim's family, the living victim and the deceased victim's family support the bond reduction.
Mr. Barrett?
Yes, sir, Your Honor. Your Honor, unfortunately, you forfeit some rights when you kill a person and try to kill another. Schoolwork is, well, it's important. I think you kind of forfeit that right when you murder someone. Your Honor, you talk about unsecured bonds, we talked about mental health, and just the court's knowledge, the state offered to stipulate to a mental evaluation for this defendant. Said, look, you get this done by Friday, stipulate will agree, we get her evaluated. It seems that's what we're arguing here today, because she has no problem. And, they did not agree to that. So I think it's disingenuous to say on one hand she has mental problems and needs mental health, and on the other hand will not agree to mental evaluation. So that offer expired on Friday. And, since the door of bond has been open, as the court is well aware, pursuant to Article 3, Section 29, when a person commits a capital offense, bond can be denied. So our response, Your Honor, is bond should be denied. I understand the family's been through a traumatic event that nobody wants to go through, and I feel so sorry for what they're going through. But the state also has an obligation to protect the community at large. And based on what the state has seen and what is heard through testimony, Your Honor, it would be unfathomable to release this defendant on bond today. Your Honor, the state also anticipates possibly a tampering of evidence charge that may come, as you report as well, where you heard about the video that was taken and tampered with, that is evidence in this case, and there may be other charges coming. We talked about her not having a car to flee. Well, that's one thing to worry about. The state is, number one, worried about the danger she is to the community. But it's also legal to shoot somebody, as the court is well aware. So what's to stop her from doing another legal act of getting in a car, which is legal, stealing a car, and going away? If we're opening that door, that's where we're going. But if you look at the factors on bond, which the court is supposed to go to, yes, Rule 8.2, right to release. And I didn't hear a whole lot of specific allegations on that. The state, when we were talking through Section 29, the state asked that you deny the motion to reduce bond. In fact, the state asked you to hold her without bond pursuant to Article 3, Section 29.
So do you have a pending written motion for Article 3, Section 29?
The state following the argument, she's opened the door, but we're making an ordinance motion to deny bond.
Okay, that's fine. I just want to make sure I'm clear, but that's your ordinance motion.
Yes, sir.
Okay. All right, any rebuttal, Ms. Simon?
Yes, Your Honor. Dr. Webb will be conducting a mental health evaluation on Carly. He's currently out of the country. Once he returns on April 22nd. As the court knows, he's a very well-respected psychiatrist who works with children, and we lined him up. So, also, Your Honor,
Yeah, we've seen her multiple times.
since Carly has been detained, her medication has changed twice. And these are not blood pressure medications, these are mental health medications. One has included a mood stabilizer since she has been detained.
Yeah, that's what they just talked about, that she is constantly being checked and her medication is being switched around to try and stabilize her. Sounds like she has a lot of trouble. She apparently was homeschooled, very intelligent, was way ahead of where she should be, but again, that doesn't guarantee you anything.
And that was after she reported hearing voices. Again, the detention center is not equipped to deal with that. It was a nurse practitioner who prescribed the mood stabilizer, not a psychiatrist. Secondly, Carly is not a threat to the community at large. Carly's family, including stepfather, who was indeed a victim here, would attest that he does not believe Carly will still be a threat to him or to anyone at large, but she does need help. Secondly, there is no charge worse than murder. So once you're charged with murder, I don't see a charge of tampering with evidence causing you to flee jurisdiction. It comes down to it from there. Also, with proper restrictions, Carly would not be able to leave the confines of a residence. She would have no means of transportation. She was confined from not having a cell phone so that she could not communicate with friends. All of this would keep Carly restricted, and again, secure Carly and protect the community from whatever concerns there may be. But Carly's certainly not a flight risk, and she certainly doesn't have the funds to raise the current bond. But she needs more help that can be offered to her in her current incarceration.
I'm assuming, Ms. Lyon, it's fair to say that the family of Ms. Gregg that sits behind you, can I just see a hand of the family members? Is it fair to assume that family members, your argument, you present, is it fair to say, well, let me ask you this way, anybody that held your hand up, you disagree with anything Ms. Todd said concerning Ms. Gregg? Anybody of the family disagree with Ms. Todd? Okay, that's right, I just want to make sure. All right, well, there's several reasons for bond, and I feel like I've been instructing today more than I typically do, but bond is not intended to be a punishment in and of itself. It's a balancing act, and that's why I tell people all the time, it's a lot easier for me to follow the rules as it relates to these matters because they're also factually different. As the state pointed out, Mississippi Rules of Criminal Procedure 8.2 dictate, it talks about the right to release, which is in subparagraph 1, and it talks about that there are several reasons for release. One, we have to be assured of the defendant's appearance as required, or that the defendant's being at large will pose, whether it poses a real and present danger to others or to the public at large. And in that calculation, it goes through 15 different items that need to be considered, which I'll briefly go through for purposes of the record. Ms. Gregg is 14, about to be 15 if she's not already. It's her birthday in April. She does, I do appreciate her intellect and her success at Northwest Rankin. She clearly has a lot of family ties and relationships. So I think that factor one would weigh to the benefit of Ms. Gregg. The second one is the defendant's reputation, character, and health. I have found or heard nothing that would
Her name is Carly. Jamie, is there a cultural reference I don't get?
Do you not know who iCarly is?
Jamie, I'm a 27-year-old man. Do you think I know what iCarly is? Is it one of them Taylor
It's
Swifties or something?
I think it's a Disney show.
Jamie, on a scale from 1 to absolutely not, how often do you think I watch some kind of Disney kid show?
I mean, I don't know. I don't know what you do in your spare time.
Well, I don't have spare time.
Yeah, Disney Channel show, yeah.
Oh,
I never watched it. I knew of it though.
it's Nickelodeon, not Disney.
Is it? I don't know.
Well, Sarah says it's a Disney.
I thought it was a Disney show.
Haven't heard anything about her real dad.
One of
Probably
those
it's
channels.
yeah, but probably Disney wouldn't like it or Nickelodeon if they called her iCarly after what she did.
Be a negative
She,
connotation as it relates to Ms. Gregg, so I would find that be a neutral factor. The third factor is the defendant's prior criminal record and any releases on recognizance of bond in the past. There have been none of those things. Those would be to the benefit of Ms. Gregg. The identity of responsible members of the community who will vouch for the defendant's liability. We just had a show of hands of family members. There were numerous family members here who support Ms. Todd's argument about the issue of bond. That factor would weigh in the benefit of Ms. Gregg, whether violence or lack of violence in the late commission of the offense. Well, that's significant. The violence is significant. Not only is the best evidence today, the testimony was that the violence with the mom was to such an extent that it doesn't appear to be any great argument prior to it. It seems to me that the defendant walked into her bedroom where her mother was and shot her 3 times, twice in the head. So, and then laid in wait, played with the dogs, laid in wait for nearly an hour waiting on Stepdad to come in, and then shot him multiple times, or shot at him multiple times, striking him at least once. So violence is pronounced, the violence is significant. That clearly weighs against Ms. Gregg. The nature, item 6, the nature of the offense charged, the apparent probability of conviction and the likely sentence, insofar as these factors are relevant to the risk of non-appearance. It's a murder, it's a first-degree murder charge. It is an attempted murder charge. Probability of conviction is high. The likely sentence is going to be significant, I understand, because she's a minor at the time the events were committed, that there may be some leniency on the back end of that, but in any event, the likely sentence is going to be long-term, and they are relevant to the risk of non-appearance. That factor would weigh against Ms. Gregg. The type of weapon used, it was a handgun used here. I believe it sounds like a revolver, but in any event, it doesn't matter. It was a handgun that was used against both victims. Number 8 was the threats made against victims or witnesses. That's not applicable here. Number 9, the value of property taken is not applicable. Number 10, whether the property allegedly taken is not applicable here. Number 11, residence of the defendant, including consideration of real property ownership. Think of residence of the defendant's domicile. Ms. Gregg is a Rankin County resident. She's too young to own real property, and I would assume she spent most of her life here, but at least we know the last couple of years apparently. That factor really is of neutral content. Number 12, the case where the defendant is charged with a drug offense, that's not the case, so that's not applicable. 13 is consideration of the defendant's employment status and history. We have, as Ms. Todd pointed out, she's 14 years old. She has no employment. She has no work history, so that's a neutral factor.
She, I think, jumped out of the window. That's how she fled the first time. No, but that's what her defense lawyer said. There's no possibility of her escaping But again, family could help her escape.
Or she could
Number
just
14,
take off
sentence
herself. She doesn't seem
enhancements.
very
Again,
stable.
Sorry?
I said, or she could just take off herself because she doesn't seem very stable.
Yeah, that's probably the biggest concern I would have is fast drop, short stop. Because again, she seems, if she already changed her medication, this is within weeks after it happened, and she changed her medicine twice in that period. She must be in a very unstable mood. So it could be could be a dangerous thing to send her home with family members and say, you have the responsibility right now. But again, it's 14-year-old in Gen Pop. That's probably not fun. Because of the crime. The crime is so bad, you will be tried as an adult. They do that in some cases because, again, this is premeditated. They are charging her with. It's first degree. It's not manslaughter or an accident. This is first degree, which is the highest degree. So that's why they're charging her as an adult.
Including the charging document, which we don't have at this point. 15, any other factor, circumstance varying on the risk of not appearing from the danger to others or to the public. All right, that brings me to Article 3, Section 29, which the state has made a more intense motion to deny bond to the defendant. And Article 3, Section 29 of the Mississippi Constitution indicates that in paragraph 2 and 3, paragraph 2 dictates that if a person is charged with committing an offense is punishable by death, life imprisonment, or imprisonment for 1 year or more in the penitentiary, and that upon hearing finds probable cause that the person has committed a felony by bond. That really doesn't apply. That's paragraph 2. We go to paragraph 3. It charges an offense punishable by imprisonment for a maximum of 20 years or more, or by life imprisonment, which is certainly applicable here. A county or circuit court judge may deny bail for such offenses where the proof is evident or the presumption great upon making a determination that the release of the person arrested would constitute a special danger to any other person in the community, or no condition or combination of conditions will reasonably assure the appearance of the person is required. I do believe that Ms. Gregg does pose a special danger to others. I mean, I know the family knows her better than I do, but the heinous nature of the crime, the premeditation that seems to have been involved here is pronounced. It's severe, and it does concern me. It does concern me that there is a danger, Ms. Gregg, whether there's a mental component to this or not. I think anybody could argue that if you're going to kill another human being, then there's going to be a mental component involved in most of those crimes where someone's murdered. But anyway, the particular facts and circumstances of this case do cause me pause. While I do appreciate the state's petition or argument about denying for bond, I'm not going to deny bond under Article 3, Section 29. So I am going to bond guidelines, which is the Mississippi Rules of Criminal Procedure 8.2C, or bond guidelines, which the state provides, which are presumptively reasonable. The defendant has made an argument for an unsecured bond, which is completely inappropriate on a murder charge. An unsecured bond.
Yeah, and again, she had just changed it a week before the incident. So that's 3 times within probably a month and a half. That shows that they don't have any idea about what was good for her. They probably were searching for the right thing when it happened.
You put up absolutely no money, and they would have no skin in the game, as I call it, for appearance purposes or risk purposes, so that would be clearly off the table. 8.2C, the bond guidelines dictate that for a capital felony, the bond guidelines are $25,000 to no bond or no bail allowed. manslaughter or any other non-capital crime involving the loss of human life, $10,000 to $1 million. It's easily, and then the non-capital offenses punishable by maximum 20 years or more, $20,000 to $250,000. $1 million is on the high end of the range, but it is within the range. I have some compassion for the defendant's particular status in life, being young and being exposed to this. I do find that, I do believe that it is difficult to be in isolation 23 hours a day. I get that. I don't think I would enjoy that either. But as the state points out, when you commit crimes of this nature with the violence involved in this crime, with the proof being so heavily weighed against the defendant.
Venus, this is the first hearing in the case against Carly Gregg, a 14-year-old girl who put 3 rounds into the face of her mom, then called her friend and said, "Can you come over? There's an emergency." And the friend comes over and she shows her the deceased mom. Then she texts her stepdad, or before that, she texts her stepdad, asks, "When are you home?" When he enters the house, she puts one in the shoulder of him. So quite a scary cookie. I have to take care of a dog that's barking.
Even at this point, that there is too much cause for concern on my behalf. I'm going to leave the bond at the upper end of the range, which is $1 million at this particular point, and I will be open to anything changes down the road. If we end up with more information, more facts, Ms. Todd, I'm happy to revisit the situation later. If we have different facts that come up, different circumstances or different things that we know about as they exist today. So I am going to set a bond at $1 million collectively for the 2 charges. In addition to that, were she to bond out, she must appear in court when required by all orders of the court. She has to notify the court of any change of address. She cannot commit any other crimes, which usually is the one that trips people up. Not possess, be in the presence of weapons of any kind. She has to be involved in an online school system. If she does make bond, she has to obtain an alcohol and drug assessment and comply with those recommendations. Cannot consume alcoholic beverages, illegal drugs, or misuse prescription drugs. She can have no contact with Heath Smylie until released by court if she makes bond. She also has to obtain a 1-piece no-cut fiber or GPS ankle monitor. And in that monitor, she has to keep it operable and charged at all times. If she has a passport, she has to surrender it to the circuit clerk's office within 48 hours of release. She has to abide by a court order curfew of 10 p.m. to 6 a.m. And until final disposition of the case, she has to maintain that GPS monitor. She will be subject to continuous bond monitoring by court watch or correctional counseling of Mississippi, and she has to continue to follow the directions of the mental health physician. These are all assuming that.
Welcome, Fadoxy Mom. And please enjoy chat. It's SAC-free today, so it's an enjoyable chat today. Jamie will promise, as it's your first day, as it's your first day, Jamie won't yell at you today.
No.
No, welcome.
Welcome.
She finds
You're
out
welcome.
at this particular.
I can't hear you when it's playing in court.
Oh, I just said welcome too. Sorry.
Time. All right. But that disposes of those issues today. Anything else besides?
Your Honor, other than she's not allowed any visitors while at the detention center. However, I believe the maternal grandparents would like to
Yes.
visit with her.
All right, I'm gonna tell you the same thing.
I haven't seen trial dates. There's supposed to be a hearing. There was supposed to be a hearing today at 9 Mississippi time. I don't know, banana time zone. But it's been rescheduled to 2 p.m. Eastern Standard Time. Zach is lurking. So is Brandon. Hey, Brandon.
I told Mr. Walker a while ago, when you leave here, if you go behind to the jail, hit the intercom button, talk to Jordan, and just tell Jordan you just left out of here. I talked to Jordan in the hall earlier. He understands there's a large presence of family here. He's going to try to accommodate some limited contact at that point. So go try that. And if for whatever reason that doesn't work, let Anita know. But we're aware of that. We're going to try to make that happen.
Thank you.
Okay. Anything else, Mr. Perry?
So that's just for today, correct, John?
Yes, sir.
Thank
you. All right. Okay, that'll conclude the matter in 24-15875.
Your Honor, may I do this?
Yes.
Yes, haircut.
All right, Mr. Powell,
Yes, Your Honor.
how are you, sir?
Good, no.
Come on up. How are you? Yes, yes.
I think we're going to talk about this question.
Go ahead. Thank you. Go ahead.
So that was
There you
her
go.
first hearing for bond, and if she had, if they believe she had done it, quite scary, I believe. If it is what they claim, that they have her on camera taking the pew pew in there, cold-blooded. It's going to be interesting. It's probably going to come down to some medical evaluation.
Mm-hmm. For sure.
Yeah. I have to look up the rules in Mississippi, how they are, but they're probably, but again, she's been tried as an adult. I don't know how it works. Yes, it's really, really a scary case, but this is what we do on this channel as well. We don't always get the Bradley Yawns. Most of the times we get horrible cases with horrible results. Jamie, we should really stop being live trial streaming and just make potpourri.
Mm. Nah, that doesn't sound fun at all.
You don't want to make potpourri?
No. Not into it.
Hey, Lynn, I thought you were a crafty type of girl.
Oh, goodness, no.
But I also have, from a month ago, there was a competent, Jamie?
Competency.
Competency hearing in the same case. Now the real one isn't going. So let's do that, and then we'll end it and set up one for later if and when it gets going and they have a feed of it. Rumor has it from Jody that it'll be shown on Smart TV, the website. I hate when they do the website because there's more ad breaks in their coverage than there's in the Super Bowl game. So if they have it, we might do it tomorrow instead, so we don't have to listen to, did you know your 401k is in danger? With Birch Gold, you can secure your 401k. Rule blah, blah, blah lets you invest up to 42% of your 401k in gold. Old.
Well, now I want
You
to
don't
hear
want to do
more.
that. If I'm going to listen to the commercials, I want to cut. I know I'm a bad grifter, so I don't put up all the grifting. I could run ads every 10 minutes like someone else does, but we don't grift enough on this channel, Jamie. You should really be better.
I try.
Yeah, but I don't want to. I don't want to pay. Pay. I don't want to spend time listening to other people's ads.
No.
by the way, September 7th, we will be having a giveaway. If you are a subscriber to the channel, you might be able to win some of the prizes some of the things we give away. There will probably be books, Legos, and a lot of candy. Jamie will demand parts of the candy, but
I
you'll
will.
have to fight her over it.
Mhm.
Well, I do have ads on in the beginning and the end, and when it reruns, they just put it in automatically, but I don't put it in during the stream. So all the ads you see is not any I get money for. Well, 7th of September, and you have to participate.
I might need your.
On behalf of the defense.
Where's your timer?
We have, the only matters noticed for hearing today are document number 22, a motion for mental evaluation and McNaughton analysis. Document number 23, a motion for issuance of subpoena ducis tecum to youth court. Document number 24, a motion for issuance of subpoena ducis tecum to Blue Cross Blue Shield of Mississippi. And document number 28, a motion for issuance of subpoena ducis tecum to the Rankin County School District. Additionally, while we're here today, the court's going to conduct the section 223A, subsection 11B, Juvenile Justice Act hearing that's required every 30 days. All right. This was the state's motion. We'll begin with the issuance for subpoenas ducis tecum. All right, let's begin with the document number 23, the motion for issuance of subpoena ducis tecum to the youth court. Is there any objection to that by the defense?
There's no objection to any of the subpoenas by the defense.
All the subpoena ducis tecum,
All the
correct?
subpoenas ducis tecum were finally being issued.
Do you have,
I believe the pew-pewing happened in March of this year. Well,
Yes, that's
Brandon,
what you said.
I will make you a special little goodie bag with candies in it. I'll make a brandy, yeah, a brandy Brandon giveaway special for your birthday.
Yeah. I want Brandon to try all this crazy candy.
Yeah,
Pretty good.
I should send him some local beer. Sadly, I can't ship them.
you have copies I can execute today?
I have orders on.
This is a month old because we were supposed to have a live hearing today, but it got pushed back, and we'll try and see if it comes on later, or we'll try and find it for tomorrow. And send what to Jamie? The candy? No, I'll send it to you.
The school district and Blue Cross Blue Shield, the state would withdraw its motion with regards to the youth court.
Give me the order. Should say.
Yes, sir. I don't know if you need to do this, Mark.
We'll give these to the court administrator and get a copy of them from the clerk's office, okay?
Thank you.
Jamie, didn't he just say, I want a special prize? And 2 seconds
did.
later, no, I don't want it.
Also, you can share it, Brandon. So she
Sharing is
appreciates that.
caring, Brandon.
Yeah. You can share it with her.
It starts September 16th. That's the same day Sarah Boone. No, it's the same. No, this is the one. I have it in my calendar. Teen Killer. Yes, I have it. So I had planned it.
All right. State needs to give me an order withdrawing your motion for subpoena ducis tecum to the youth court, please, with MEC claim. All right. All right. Next matter on the docket is a motion for mental evaluation and McNaughton analysis. All right. Is there an objection to that by the defense?
No, there's not an objection. We just wanted to make sure that that would occur, the state's mental health evaluation would occur after Dr. Webb has finished his mental health evaluation, which should be finished in July.
I can't assure the defense of that. I don't know, so we're
Because it's a first-degree homicide.
on a pretty tight time frame here. This case is set for trial, I believe, in September, is that correct?
Yes, Your Honor.
When is Dr. Webb's report going to be finished?
He should be finished with his report by, I want to say not the 12th, but the Friday after the 12th.
Okay. Has the state already spoken, looks like you spoke to Dr. Amanda Gugliana?
That's correct, Your Honor, and she's ready to proceed, assuming that our motion is granted as soon as possible, since we know that we have a trial date in September.
Okay. All right, so you have no objections other than the fact you want to happen after Dr. Webb's analysis, correct?
Yes, Your Honor, and according to Rule 17 of Mississippi Rules of Criminal Procedure, that's technically the way that it should happen, is the state puts forward their mental health evaluation, or the defense puts forward their mental health evaluation, and then the state can proceed with the mental health evaluation 10 days after we have declared whether or not, our expert has declared whether or not Carly is competent or incompetent for trial. And as of right now, that can't, yes.
Your Honor, I'm not aware of that being in Rule 17. That's about discovery. Rule 12 is what talks about mental evaluations, and the state is not aware of anything in the rule which requires it to wait until after the defendant has completed its evaluation.
Right. Well, let's do this. The only issue that we're in disagreement on is the timing of it. It's the state's motion. I'll let the state argue, then I'll let the defense argue, I'll let the state reply, I'll rule, and we'll be finished. All right? So, please step to the podium, Ms. Step to the podium. Ms. Newman, I'll hear what you got to say.
Your Honor, the state filed a motion for mental evaluation and McNaughton analysis on June the 17th of this year. Pursuant to the case law cited in that motion, as well as Rule 12, which governs mental evaluations in criminal matters, either party or the court on their own can request that an evaluation be done if there's reasonable grounds to believe that such evaluation should take place. Pursuant to the defendant stating multiple times that they had hired a private evaluator, Dr. Mark Webb, to conduct an evaluation, the state believes that the insanity defense has not properly been alleged, but believe that upon information and belief based on their arguments regarding Dr. Webb, that that's what the defendant intends to introduce as some sort of insanity defense. The state is not required to sit back and wait for them to produce a report claiming that she's insane before funds can be acquired and evaluation can be started on behalf of the state. In fact, the case law talks about once doubt is raised as to someone's competence or insanity, the state bears the burden to prove that they are in fact competent and they are in fact sane. And so the state should not be required to rely on a report by Dr. Webb, who is a private evaluator paid by the defendant, before we are able to have the defendant evaluated. Specifically, we have gone ahead and contacted Dr. Amanda Gugliano, who is one of the psychologists who is certified to complete such evaluations through the Mississippi Department of Mental Health. As the court's aware, the way that the evaluations are conducted back in November of last year changed. And so there's two options for the state of Mississippi. We can go through the state hospital and have them assign someone, or we can go ahead and select someone and contract with them directly. We've chosen that option in order to streamline the mental evaluation. Our trial date is quickly coming upon us. There's nothing to require Dr. Webb to complete his evaluation by the date that counsel has stated in July. There's no guarantee that that will happen. Again, the state's not required to wait until he does that. They've offered no response to our motion. They filed no response. They provided no case law or cited to any statute or law that requires that we wait until after their evaluation is conducted. In fact, the state also, prior to coming to circuit court, tried to agree to a mental evaluation on behalf of the defendant. There was communications back and forth where the state said we would not wait indefinitely in order to have this done. We did not want to have so to speak, them to drag their feet and say, well, we'll agree to it, but we'll sign it when we want to. I spoke with counsel, Mr. Kevin Camp, he's not in the courtroom today, but I feel certain that he would agree with me, that I told him that we would have agreed to an evaluation. However, there was a deadline put on that, so that this case would not sit unindicted and without a new evaluation. Excuse me. Pursuant to our motion, we do ask that the defendant be evaluated both for competency to stand trial as well as a McNaughton analysis. Again, to streamline things, we prefer that it be done at the same time rather than one and then ordering that the other be done subsequent to that. We've asked that any medical, psychiatric, psychological, educational, addiction, or employment records and privilege be waived so that Dr. Giuliano can achieve her evaluation and she can get any records that are necessary, which is also why we filed our motions for subpoena duces tecum that the defense does not object to, in order to get her school records and Blue Cross Blue Shield medical and pharmaceutical records so that we know each and every provider that she saw. The state is again asking that our motion be granted and that we be allowed to use Dr. Giuliano to have this defendant evaluated as soon as possible rather than having to wait until after Dr. Mark Webb has completed his analysis. Thank you.
Response by the defense.
Yes, Your Honor.
Your Honor, Rule 17.4 of the Mississippi Rules of Criminal Procedure states that.
There is a lot to unpack here. So the best person to do.
Shut up. I don't care.
Or of the Mississippi Rules
18-year-old girl, Carly Gregg, Ashley Smylie.
of the Mississippi Rules of Criminal Procedure states that if a defendant intends
That's why I don't want to cover it off their website.
to introduce expert testimony relating to mental illness, defect, or other condition bearing upon the issue of whether the defendants had the mental state required for the offense charged, the defendant shall, within the time provided for filing pretrial motions or at such time as the court may direct, serve upon the prosecuting attorney, the clerk of court, notice of such intentions with the names and addresses of such expert witnesses upon which the defense intends to rely. The prosecuting attorney shall serve a notice on the defendant promptly, but in no event less than 10 days prior to trial, stating the names and addresses of any witnesses whom the state intends to rely upon relating to the issue of the defendant's mental condition at the time alleged. The way it's intended, and even the notes under that, talks about the defendant raises it, puts forth their expert opinion, then the prosecutor can rebut if it is found that the defendant has found that they're going to rely upon that. However, at this point, we don't know if we can rely upon that because our expert has not finished his mental health evaluation. Dr. Webb is very reliable, very good at his job, but it takes time. And in this situation, we had a child who is being charged as an adult, but who nevertheless is being kept in solitary confinement 23 hours a day in an adult facility where he then goes to see her. And also immediately after she was arrested and detained, she was placed on various medications, one being Abilify, which was an antipsychotic, by a nurse practitioner. So there have been medication issues too that Dr. Webb has had to wait to weigh and see what, if any, effects those were having on her. And that's why it's taking a little time. But like I said, he is due to be done, and we are able to produce his mental health evaluation the Friday after July 12th.
Yeah, all of it sounds really, really bad. And again, we haven't really heard any motive, any reason other than what I can get is mental health. That's where I am.
Well, yeah, and people are very unpredictable. You cannot, you never know what is going to happen. Just because somebody's on medication doesn't mean they're going to do stuff like this. You can never really know.
Yeah, and again, it's you don't because people are saying, well, it's the this or it's the that or it's the Ritalin or it's the we don't know. That's why they need this hearing or this examination by a doctor to figure out why she. I have a dog barking.
I'm not sure how long the state's expert will need or what testing will be involved, but that's well in advance of the September trial date.
Anything further?
No, Your Honor.
All right, the trial.
Your Honor, again, 17.4, sorry. Rule 17.4 comes into play once the defendant has filed a written notice. The defendant has not filed any type of written notice in front of this court. The state, however, has provided written notice that we intend to solicit the testimony of Dr. Amanda Gugliano, who is a certified psychologist who would do the testing on the defendant regarding any insanity and/or competency. We believe at a minimum, she should be able to get started on her competency evaluation with regards to this defendant. Again, there's been no written notice provided by the defendant to put Rule 17.4 into play. With regards to medication that the defendant may or may not be on, again, if the defense attorney would look back, they would see that the state actually agreed to have her assessed by Region 8 in the beginning, and it was our intention that she be assessed by the Mississippi State Hospital at that point. However, the orders merely provided that she be assessed by Region 8 for evaluation and treatment. We've been asking since the beginning that.
It's so weird to see a person like this, and you instantly, because I remember when my kids were 14 and they could never ever. But then again, you think about some of those horrible cases where kids that age just go absolutely crazy.
Yeah, and it doesn't mean any. I mean, she could have just been wanting to do it, and it sounds crazy, but it happens all the time.
Yeah, and even if they don't have any treatment or not treatment or anything, some of them just, if you tell them no, they can just. There's a lot of entitlement in young people today. It's This is the newest hearing. Well, don't be alone with her. Yeah, but it's just because now we are sitting here thinking, oh, it must be her borderline, or it must be her medication, but that kid's out there every single day doing something absolutely abhorrent. It's we have a big problem right now in Denmark where they hire pew people to come to Denmark and unalive. We have an ongoing gang war. And they are 15, 16-year-olds who come pew up their competitions. In Denmark, it's a lot of barbershops and places like that they use as a front. And they don't care. It's but that's the frontal cortex not being fully developed. And we all remember how it was to be 14. Nothing could hurt us. Nothing could do anything. We were going to live forever.
And you make a lot of rash decisions that you're like, oh, that was dumb.
Zach has given his expert explanation after listening with half an ear for 23 minutes. He believes it's the gremlins in the water. And there's a lot of water in the Mississippi River. Yeah, that's the place you would normally go to because she changed her medication so much. But I also seen people being medicated that gets very docile and would never ever act out. So it's and again, she looks a little bit not with this hair, but the one she had at the first hearing, she looked a little bit like the Children of the Corn.
The Children of the Corn. Yeah, and like, I don't know, the move she made to do this, commit the crime, was pretty.
Yeah, she disconnected the camera, and then she called her friend over. That's another thing. You sit there and think, what the F is going on?
Yeah, and then she called or text the stepdad to say, where are you at? Just to shoot him when he came in, or pew him, sorry.
Yeah. Yeah, and again, it's because we want to be here and find. I think that's the biggest problem for reasonable people. We can't understand why anyone would do something. It must be something that made them do it. And some people were just born bad. And I think that's one of the biggest problems we have as a society is we think everyone can be, if we just put them on the right drugs, or we just pat them enough on the back, or we just tell them, well, you're good enough, then everyone will be good. But some people are just born wrong. Something is wrong with them. And we talked about this with the last case, where I say one of our biggest problems is mental health has become way too much. Well, you are okay. Let's just curdle you a little bit more, and we just go along and say, yeah, you're right, but try and change you a little bit. Some people would have a better time. I'm not saying cuckoos, one flew over the cuckoo nest mental institutions, but in an institution where they wouldn't have to interact with a society they just can't interact with, because some people are bad eggs.
Mhm.
No, her stepdad is away from the home. She texts him and say, when are you getting home? And then she calls her friend and says, hey, we had an emergency, come over. And she shows the mom. And that's, to me, that's not just someone who just got the cray pill wrong and went. This is going to be interesting, Jamie. I want to hear her
Yeah.
psych evaluation.
Mhm.
To be evaluated, and we believe that it would be in both sides' best interest in order for judicial economy in this trial not to be continued if our evaluator would be able to proceed with her evaluation as soon as possible. Thank you.
All right. Court, then, having heard arguments from both sides, court is
I believe he was outside. She was outside when she did it to the dad.
Not concerned with the particular written notice.
But yeah, we have the same in Denmark. I think it's all over the Western world because we believe pharma can fix you. And it's hard to say, because I know there's a ton of, Denmark has the highest rate of what we call happy pills, or happiness pills, antidepressants. We are the country in the world who use most of them, probably because we live in a place that's so dark. But the reality is, you can medicate some people, but you can't take evil out of them. And some people are just bad people. And I think we as a society think we have evolved beyond nature. But in reality, some people are really, really, really bad. And we just don't want to see it because we will believe that we are good enough to fix bad people.
The courts relying mostly on Ballard versus State of Ottawa County. The entire purpose
I think she is bipolar. Yes.
of the notice requirement is to prevent trial by ambush for either side. Neither side should be surprised at trial. While I understand the rule says not more than 10 days, it also says unless otherwise ordered by the court.
Yeah, but I also think, Jill, especially with bipolar, it's really hard to hit the medication right. It's to say, bipolar and borderline is kind of the same thing. I had a friend who was borderline, and it took almost 4 years to get the medication dialed in with the borderline. It was really, really hard because the mindset changes so much, so they could think, oh, they are well treated right now, but that's just the disease that makes them look like that. But when they break, they just break harder because the medicine wasn't right. So it's really hard with these mental illness cases. That's why I'm saying instead of putting all these money into drugs, maybe treatment.
But I'll notice y'all are otherwise ordered by this court. We're not going to wait till 10 days before the trial to release all of our information. All right, while the court would prefer for Dr. Webb's report to be complete, I believe this court's experience with mental evaluations is normally done in multi-stage on multiple days. So for that reason, the court's going to grant the state's motion for mental evaluation and all analysis. The court is not going to limit it until after the release of Dr. Webb's report. However, I do believe from a practical matter, Ms. Guglielmo is somewhat
Yeah, and especially because she's a teenager. Teenagers already have a ton of chemicals running through their body. So I think it's even harder to dial it in at that age because our bodies change, all the hormones. We all remember how horrible we were when we were teenagers. Not Jamie. Jamie was a sweetheart. The rest of us, we were kind of a-holes to our parents. Yeah. Electrotherapy, actually, they are beginning to use it again against certain illnesses. I didn't want to have the one where it's the same with lobotomies and stuff like that. I don't think we should go that far. We should secure them and make them have a good life.
strong until she gets Dr. Webb's report. Dr. Webb's report comes back and says that, hey, there is no McNaughton issue here. We'll double back and we'll do it. Okay. But what the court doesn't want to do is delay this case. As defense counsel said, she is this court revoked her bail and she is being held without bail. So I intend for this trial to go forward in September. All right. For those reasons, the court will grant the motion for mental evaluation. All right. Now, as to the Section 223A, subsection 11B of the Juvenile Justice and Delinquency Prevention Act concerning juveniles charged as adults. All right. Does anybody have anything it wishes to add on the juvenile justice hearing?
No, Your Honor.
Anything from the defense?
No, Your Honor, other than there was an incident where an adult inmate who was being housed in the same pod area as Carly was making threats to harm and physically assault Carly, but Carly was able to tell her grandparents, who were able to tell me, and I was able to get someone from the detention center on the phone to handle it.
Yeah, and that's the thing. Because of the crime, yes, I think it's appropriate to try her as an adult, but you have an obligation. She's been threatened at the facilities by older inmates. You still do have an obligation for this poor little girl, no matter how bad she is.
Yeah.
Mr. Chandler, she being housed in the general population?
She's isolated, sir.
She's isolated. All right. I don't tell the sheriff how to run his jail, but I believe our sheriff has enough good sense not to put this young lady out in the general population at this point. Court looks at the following factors. Age of the juvenile, she's 15 years old.
I believe because she's been in isolation, but they slipped notes under her door with threats on it. I believe that's what I read in some paper.
Mental maturity of the juvenile. Court heard at previous hearings. She's very
No, this is if she should have a mental evaluation, and he granted it.
intelligent juvenile. Present mental state of the juvenile includes whether or not the juvenile represents a risk of self-harm. There was prior testimony regarding self-harm of this particular juvenile while she was not incarcerated. However, the court's heard of no such danger while she is incarcerated. Nature and circumstances of the alleged offense do not weigh in favor of the defendant. Juvenile's history of prior delinquent acts. I believe the state court doesn't have anything in front of it yet. The state's moved for a subpoena tecum that may shed more light on that. You say you have information that she's.
Yes, sir, Your Honor. Upon information and belief, the defendant was brought some contraband, possibly a knife, to school and was sent to the Learning Center back in September of 2021.
All right. The relative ability of available adult and juvenile detention facilities. Court would know, I've worked all over the state of Mississippi. I think that the Rankin County Detention Center is jokingly referred to as the Hilton jails throughout the state of Mississippi. The Rankin County Sheriff's Department runs a very safe jail. For those reasons, the court will not have any change to the juvenile justice detention that she's currently maintained. Anything further from the state?
None from the state, Your Honor.
Anything further from the defense?
No, Your Honor.
We'll be in recess. Best of luck to both sides.
It seems like it's not over for that.
Oh, I didn't know she had also done that. Well, she's clearly a troubled person. And to me,
Yeah.
it doesn't matter her gender or anything, because again, I try to approach every trial the same way. Doesn't matter if you shouldn't get less because you stand up or sit down peeing. It's but it's just horrible being 14 years old, and that's a lot of time you have left on this planet where you have to live with the knowledge what you did. That's
Mm-hmm.
that's horrible. Hey, Fox Vices Raiders, welcome. We were just about to discuss the case we were looking at, because we have been looking at the Carly Gregg case, a 14-year-old girl who is charged with first-degree homicide because she apparently went into her mom's room or into her own room. I didn't really get which one of it was. Caught on surveillance camera in her house. She pews her mom 3 times in the face, then texts her stepdad, "When are you coming home?" Then calls one of her friends over and say, "Hey, are you here soon?" And he says, "Yeah, I'll be there soon." And when he comes home, she clips him in the shoulder and runs away. She's been held in a grown-up detention center, has been threatened. She's in isolation. Apparently, she has a really hard mental health diagnosis because they can't really figure out the medication they should be giving her. So we've just been watching 2 previous hearings because there was supposed to be a live hearing now, but it's been moved till 2 p.m. Eastern, where we'll pick it up again. Hey, JB, good to see you. Yeah, that's why it's first degree. She apparently also unplugged the surveillance camera, so there's premeditation in it as well.
Mm-hmm.
So, and I was just looking up because someone said something about if you had a certain age, Mississippi had some rules for your incarceration. So, homicide penalty for first and second degree murder or capital, except as otherwise provided for a juvenile offender in subsection 2 of this section. Every person who is, so we drop down to subsection 2 because she's a, oh, I should share this. She is a juvenile. So subsection 2 states, for the purpose of this section, juvenile offender means a person who had not reached the age of 18 years at the time of the commission of the offense. A juvenile offender who is convicted of first-degree unaliving after July 1st. So she will be hitting that because she won't be going to trial before September. May be sentenced to life imprisonment in the custody of the Department of Correction if the punishment is so fixed by the jury. If the jury fails to fix that penalty at life imprisonment, the court shall fix the penalty at not less than 20 and no more than 40 years in the custody of Department of Corrections. Capital murder, isn't this one before? Isn't that one? So if she doesn't get live, she will serve at least 20 years in prison for this one. I think someone said there was a time limit. So that's 20 years in Mississippi, a 20-year time limit before they can be let out. Hey, Francis' mom. Paul poor pitiful doesn't invite. Oh. Do the adult crime, you should be charged the same as an adult. She is charged as an adult, but apparently a juvenile will get a different sentence because if she had been an adult, it would be life. There's no other punishment than life for an adult in Mississippi. Hey, Joe. Hey, Raiders. Welcome.
Yeah, because if they're minors, it's more high probability that they could be rehabilitated. Because that's the whole point.
Yeah, and yeah, there was a Supreme Court. I remember it where they must give them an opportunity to get out earlier.
Mm-hmm.
No, I don't think that has to be capital. Yes, convicted of capital unaliving shall be sentenced to unaliving, to imprisonment for life in the state penitentiary without parole, or to imprisonment for life in the state penitentiary with eligibility for parole as provided in section 47-7-3. So no DP unless it's capital. Talking about this. Because yes, she's been tried as an adult. Yeah, well, we have that rehabilitation mindset for everyone. That's why we, as I stated yesterday, if you grape someone, 2.5 years is probably the maximum you'll get. What length of Corey Ritten's trial? Thanks. Corey Ritten's trial hasn't started yet. There was a hearing last week we haven't watched. I was thinking about doing that tomorrow. And next week, there's 4 days set aside to pretrial hearings. I don't know when it's supposed to go to trial. But I know there was a hearing last week we still haven't watched because it was we were doing something else. But we'll have to watch the hearing some other day. Yeah, I think they have a bad history of unaliving people, so they don't do that. Texting the dad, when are you coming home? Clipping him in the shoulder, taking the pew-pew to another room, hiding it behind the back, and disconnecting the surveillance camera. All of that to me seems like intent. But again, as always, innocent until proven guilty. Well, as I always told my kids, that I'm not your friend, I'm your parent. That's why I'll treat you really, really nice as long as you know the boundaries. If you cross the boundaries, hell will be right across the boundary. The boundaries will always be clear. Monday won't be different from Tuesday. It's always the same boundaries I have. Until you cross the boundaries, I'll treat you nice and friendly. If you cross the boundaries, hell is waiting. I was brought up that way, and I think I came out okay. I think a lot of people have problems today because kids have become a project more than something you did when you were drunk. So when they wait till they are 38, 40 years old to get their first kid, and it takes them 3 years of what's it called, Jamie? The medication thingy.
What?
To get pregnant.
Like to make you pregnant?
Yeah, what's the medication you go on to get pregnant?
I mean, like
I
fertility pills?
Yeah, some fertility things, and you spend 3 years and you just don't get that one kid, you're going to treat
Yeah.
them like the prince or the princess. Back when kids was something that happened because, it'll be fine. I think we were a little more. It's the same with school teachers and everything. Oh, it wasn't my prince or princess who did anything wrong. It was all the other kids. No, you should tell them, shut up, sit down, learn.
Mhm.
Well, it doesn't matter if you do it grown-up crime, you do grown-up time. Because again, it's not okay to unalive anyone, no matter if you're 3 years old or 30 years old. She has a 3-day preliminary hearing. Yes, that's in next week, and then no trial date. Thank you so much, Jess. Well, we try to find something.
Mhm.
If she just said it's not intentional, everyone knows she's free to go.
Right.
No testimony so far about it. I never had a spanking because it was allowed back then, but it was frowned upon. And today it's actually illegal to spank your kids in Denmark. Even grabbing them in the arm would be seen as an assault. But I still think you can give limits and say, this is the boundary. Cross this. But too much iPad, too little. How was your day? I think a lot of kids will act out if they don't get attention.
Mhm.
That's what do I know? I'm a baker. I'm not a child psychologist. Sarah also had 2 things due by Friday, so expect some filings in that case at some point. Yes, she'll be back in court September 26th, Sarah Boone. Yeah, and Bev still haven't responded to the jury stuff. That's right. Yeah, and I think that people should really get back to some of it. Just go into any restaurant today and see how many kids, small kids, are doing this. But it's so much easier. Then little Billy won't complain. No, you tell Billy, shut up. Sit on your butt. We are out eating. You teach him a life skill that little Billy needs to move his need for gratification, because life is all about not getting what you want. If you give him everything he wants, he'll grow up to be an entitled brat. Yeah, there's a lot of I can see on my numbers I should be a Karen Reed all the time channel. It's really good for my numbers, but it's also I like covering different trials.
Yeah, me too.
Kids thinks they're adult equal to adults these days. Kids should not be the same level. They definitely think they are entitled. I in jest, before anyone kills me over this one, I told my brother and my sister when they got kids, said, kids and dogs are kind of the same. You have to make sure they understand who's the boss. If you don't tell them, they are the boss. And I still believe that if they know you get whacked on the nose with a newspaper if you do that, they don't do it. I agree. Shut up, Billy.
Shut up, Billy.
Yeah, I've my youngest daughter had a bit of an attitude, and still to this day, she's 20 years old. If she uses, and it's funny coming from me, who might use potty mouth language a few times, I'll still tell her, stop doing that, and she'll, and I'll say, I don't care. It might be of legal age, but I made you. I will always be there to tell you what's right and what's wrong. My kid told me, no, I don't care now. Love it. Well, you better stop that and tell him, I don't give. It's the same with when they throw themselves on the floor. I don't know this. Statute of limitations. We were out shopping once, and she got mad and threw herself on the floor because I didn't want to buy something. I just walked on, and her mom said, no, we can just move on. Went down the next aisle, and she was screaming for like a minute, and then that was fixed. She didn't do that again.
Most of the time they don't. Too much coddling nowadays.
Yeah, just remind them when they get kids, even though it's so easy to put on YouTube, and everyone should be on YouTube. Remember to go around checking all the ones you normally follow, because YouTube is unsubscribing you if you follow a lot of live streamers. Make sure you still follow them. Just a heads up. Just tell them, don't do the easy thing. What does AOC mean? I think that's a company that makes computer monitors. I don't think, well, my kids I think they got cell phones around when they were 10 and 12 or something like that. But we were at a family thing, and we were sitting at a table eating, and then when we were done eating, I thought, well, I don't see my kids that often. They're grown-ups, and we have been divorced for a lot of years with the ex-mom and I. And their then stepdad was there. Me and my oldest and the stepdad, we were sitting talking about, it was when she graduated. And we were talking about that, and that was nice. And my youngest daughter's boyfriend and their mom were all sitting with TikTok. And I was just, Jesus effing Christ. Can't you at least spend 2 hours just talking about how's your day? You are correct regarding training dogs and cats. Sometimes, like dogs, kids can be feral. Yeah, and you can give them a treat and they'll be better. But I just think one of the most important things for kids is like with dogs. You have to have a set schedule so they know these are the rules. Because kids don't understand consequences. So if you don't give them rules, they'll try and break them. Not try and break them. They don't understand why you get angry when they break the rules you don't give them.
Well, they need, like, people need structure.
Yeah, and you are the structure.
Yeah.
My kids got them when they got a job and saved up for them. That's a good way to do it too. Well, my daughter started working when she was 13, so that was around that time. Yeah, and I think that's a good thing because my daughter was in probably the 5th or the 6th grade, and one of the girls in her class had taken some photos. In Denmark, when you have PE, you all go into the dressing room and you just have one big communal shower for each gender. And one of the kids had taken some photos in there and sent it to the boys from the class. And she, that's just a joke. No, that's actually a really, really big crime. But she didn't. It's funny. I just got my phone and I can text pictures of the other girls nude. Yeah. First of all, underage girls, even we have a 15-year-old, 15-year-old is the sexual legal age in Denmark, and these were like 12. So that's kitty corn. And spreading kitty corn, that's a big problem. What did her parents say? Well, it's just a joke. No, you should say, thank you so much. We are so sorry. She will never, ever, ever have a phone again until she had learned what she did wrong. No, the problem was it was just a joke. That's the problem with kids these days. The parents don't want to be parents.
Mm-hmm.
Yeah, and again, so many people. Snapchat. Well, I'm just gonna Snapchat you, and people they should be the smartest people on social media because they grew up in an age of social media. What do? Hey, someone want to talk to me on Snapchat? I'll better say yes. Do you know the person? Nah. How stupid are you? It's the same with me. Whenever I stream on Rumble, I get some Nigerian who want to tell me how to promote my channel. If I just send him this and this, no, don't. If you don't know people, don't connect to them. It's the same with the grandparents who, oh, I got a call. In Denmark, we have a spoofing call right now where this is the Danish IRS. I'm calling because you have Danish governmental things doesn't call you in English. So, but people still, oh, I better press the dial and get to talk with one of them. And oh, someone stole 20,000 kroner on my account. I don't know how it happened. Well, it's the last 15 years we've been told, don't do it. In the state I live in, the age of juvenile responsibility for sending corn is 13 years. Hey, Lexi. Kids need more boundaries and structures than ever. Teachers have the hardest of any profession out there. It's so important for parents to be involved with kids any day. Scary world. We just had a political party recommend that we used, I think, 20 billion Danish. That's like a 1/3 of the entire budget for the school system to teach teachers better. And I'm like, why don't we start where it really counts? Tell the parents, raise your kids so they are ready. You effing idiots. No, because that'll have no, we can't. When I was in city council, I said, can we make it so kids can't have their cell phones all day long? Let's make like a cabinet where they can put their cell phone in. Yeah, but then they can't call their parents. No, that's what the headmaster's office is for. You go down there and say, hey, I have a boo-boo, call my mom. You don't need your phone. You're at school. Said, and can we how easy is it to expel someone? Oh, we can't. We'll send them home for a couple of days. If they can't, because in the Danish law, it says that you have a responsibility to make sure when you leave your kid at school, it's ready to get education. Said, why don't we call the parents and say, hey, take your rotten kid home for 3 days. You take care of it. It's not our problem. You didn't teach it how to sit on a chair and shut up. No, couldn't do that. How about their work? Maybe it'll teach them something if they had to take care of their kids. They just dump it on the teacher, and when the kids is still an a-hole, they'll call the teacher and yell at them. I bet you the teachers could teach the rest of them way better if you didn't have 5 kids running around in the classroom.
Mm-hmm.
I should be dictator of the world. Kids with cell phones in their backpacks have saved other kids during school pupils, though. That's different than it used to be. Well, I'm pretty sure that was it Uvalde or whatever the school name, they could have called 24,000 other times. But then keep it in the school bag. If it comes out at any point, Marissa comes, picks up her kid because she didn't teach her kid that the phone no go out. If it happens again, Marissa keeps the kid home a week, but Marissa has to work. Yeah, Marissa should teach the kid not to have the phone out. It's that simple. It's, yeah, but kids do stuff. Yeah. But is your kid allowed to disturb the rest of the class? No. Boom. Let's get back to consequence pedagogic. What do you call it, Jamie?
I don't know what you're trying to say. What are you trying?
Well, if the teaching of teaching, that's pedagogue. I don't know. We call it pedagogue. When you're teaching kids, it has a name. I don't know. But imagine if Monty.
Oh my God, Monty is so cute. He's just having a good time. He's not bothering anybody.
He's bothering all the neighbors.
So.
Well, then some parents will say they stole my kid's phone. We have seen that before. So we are on the verge of get off my lawn. When I become
He
president
is.
of the world, everyone will get off my lawn. Educator. I have to go shut him up.
Baker is definitely not a dog person because clearly I let mine bark until they just bark themselves silent. So. Is everything okay? Yeah?
I'm muted. I know.
No, but
Well, I was muted until I hit the button.
what's he even barking at? What's out there?
It was really bad. There was a bird.
Okay.
But Jamie, all this talk about phones and stuff, just before we leave, I think we need a little bit of get our smiles back.
Something I've been using. I've been doing that for a few years now, and it's a very, very effective way to start my genuine and natural laughter. So there you go. You're going to take your phone and record your voice and laugh. Good. Then you're going to listen to yourself.
Oh my God.
You don't need to look outside to get people to laugh with you. You can do it by yourself with your
Not
phone.
at all. Yeah.
I cannot tell you how many times it helped me.
We lose so many viewers every time I put her on.
I don't even care. Why do you guys hate her so much? It's so ridiculous. It's funny to me. I don't know.
Yeah.
Oh,
Yeah.
she makes funny doing this. I would do this in a heartbeat if I could.
Yeah, just make the laugh yoga school and just sit there. And enjoy your natural laugh. Jamie,
Baker's like horse laugh is even creepier than hers. It's so funny.
she has a French accent.
Yes. She's a French lady.
You came back to us lightening the mood, losing a lot of viewers because we should smile more.
Yeah, you should.
So,
Take your advice.
Jamie, we'll look out if it comes on at 2 p.m. Eastern. I'll go live again. Jamie might join us. No natural laugh at that point. Then we'll go back to the bad stuff. See you all later, and thank you so much for stopping by. YouTube things, blah blah. Where's my out? This one.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Checking your other.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.